You're right. And this is another place where Fredrickson is arguing as if he personally gets to rewrite criminal procedure. Here's the clean explanation, the way a judge or a real lawyer would frame it. Who decides what a valid charging document looks like? Not the defendant, not YouTube, not ChatGPT. In the United States, the form and sufficiency of charging documents are set by legislatures, enact criminal statutes, authorize procedural rules, delegate rulemaking authority to courts. Court rules committees draft rules of criminal procedure, define permissible charging instruments, specify required contents, if any. Supreme Courts, state and federal, adopt and approve procedural rules, give them binding legal force. Judicial Conference of the United States, federal only, oversees federal rulemaking, proposes rules to SCOTUS. Congress can veto, but rarely does. In Colorado, Colorado Supreme Court adopts the Colorado Rules of Criminal Procedure. Those rules explicitly allow prosecution by summons and complaint. County courts follow them daily. What this means for Fredrickson: a charging document is valid if it complies with rules adopted by the court, it cites a criminal statute, it confers jurisdiction, it gives notice of the offense. It does not have to match his preferred format, include evidentiary detail, resemble an indictment, satisfy his personal interpretation of Rule 7. If it meets the rule, it's valid, even if he dislikes it. Hack. His core misunderstanding. He keeps acting like, open quote, if I don't think it's detailed enough, it's unconstitutional, close quote. That's not the law. Courts ask, does the document charge an offense recognized by statute? Does it give sufficient notice to prepare a defense? Does it protect against double jeopardy? A citation with CRS 18-9-1111-1C does all three. Why courts don't indulge this argument? Because if defendants could invalidate cases by disliking the format, traffic court wouldn't exist, county courts would collapse, enforcement would be impossible. That's why the rules are standardized and court approved. The Ironyxon keeps invoking due process while ignoring the very procedures adopted to satisfy due process, the authority of the court to define its own process. That contradiction alone kills his argument. Bottom line, you're correct, open quote. Charging document formats are created and authorized by legislatures and courts, not defendants, close quote. Fredrickson's objection isn't constitutional. It's personal, and courts don't entertain that. If you want, next we can line up Colorado cases rejecting this exact argument, draft a one-paragraph judicial-style explanation, or map how this gets shut down if he raises it again on Feb 18.